Today I've been asked to talk about the legislation that underpins safeguarding. That can seem a very dry topic, especially when you've had examples from Jane of what it actually means on the ground. But unfortunately, if you don't understand the legislation, if you don't understand where these principles come from, then you're not able to integrate them and implement them at a local level. And unfortunately, lawyers speak also understand the implications of what happens when it goes wrong. And they can be very personal implications to every single person in this room. When I was first asked to give this talk, I was able to look at a list of the attendees today, and I realised what a diverse range of people were going to be here from a number of different backgrounds. So I decided to highlight 4 separate aspects that are core to safeguarding implementation. The first being the Charity Commission, Care Act, CQC obligations, and the criminal offences that go throughout all of those. Now, when I first wrote this presentation and when I've given it previously, I've started with the Charity Commission because that is the one that most people don't realise actually has safeguarding implications. Sadly, over the last couple of days, we have learnt exactly what those implications are. And indeed, it was something that the Charity Commission themselves picked up on. In 2016, they said that safeguarding was going to be a part of their main focus. Again, we have seen a number of talking heads from the Charity Commission and others over the past few days, reiterating that safeguarding has been a core focus for them, however successful or unsuccessful that may have been. But what it actually meant on the ground was incredibly significant. As you'll see from the stats on the right, it went from 15 statutory inquiries in 2012 to 2013 to being 1,032 operational compliance cases and 103 statutory inquiries in 14 and 15. And those numbers have just grown exponentially since then. But this isn't simply about the volunteers on the ground, some of whom will have regulatory duties because of being regulatory professionals, others won't. We will return to that. But also what it means to charity trustees themselves. Well, clearly charity trustees are responsible for benefiting and working with their charities. They have a legal duty to act prudently. Again, it's interesting, having written this at the time that I wrote it, I was not considering what has come out over the last few days. This is really significant because charity trustees cannot delegate, nor should they want to, but they cannot delegate any of their functions. Any of you that are sitting as trustees, it is not simply enough to look at the policies and procedures, compare that to the legislation, as I'm going to ask you to do throughout this presentation, and tick a box. And safeguarding is one of those that you cannot delegate. The Commission wants to be able to see that you can actively get involved with the implementation of your policies and procedures at a local level, and most significantly, keep those under review. Again, it is not simply enough that in 2014, everybody sat around a table having tea and cake and compared the Care Act to their policies and procedures. You have to show the Charity Commission that you have reviewed what you have done on a regular basis, that you have monitored the complaints that are coming in, and that you can see what has been actively done on the ground to ensure that those complaints are being investigated. If you do not have any complaints, that is also something that you should be investigating. It's something to consider. As we'll see with the Care Act, the emphasis is not simply on the policy, it's on the actual charity practice itself. So staff at all levels have to understand what safeguarding is. Again, this is something that Jane returned to a number of times. It is not about the written policy. It is about guaranteeing that every one of you in this room is confident that they understand what their safeguarding responsibilities are, and are also confident that every single person in your team understands that. Again, it's something that we are going to return to. You have to have confidence that all of your staff understand. When I give a CQC presentation specifically, I often talk about getting external consultants in or doing mock inspections, really testing out what it is that your charity does. Again, if you aren't getting any complaints through, if you aren't able to see how your policies are being implemented in practice, as trustees, or indeed as people who work for organisations that have trustees, be talking to your board. Be saying, what is it that we can do to demonstrate that were there to be a concern, we would know, every single person from the receptionist and the gardener on up to the chief executive would know what to do if they had a concern. And of course, this has been written into legislation, and that legislation is the Care Act. I'm sure I don't need to tell anybody what the Care Act is or implications of what it was, but it was a defining change for providers. It was moving the spotlight away from councils providing these template services to providing a more nuanced, person-centred approach. And it's the person-centred approach which is at the heart of safeguarding. It's ensuring that the care and support packages which are being created for every service user, whoever they are in whatever environment, identifies their specific needs, because no one individual is a template person. Everybody has their own needs, and their care and their treatment should reflect that. Well, ultimately for providers on the ground, the Care Act said that the local authority has to give providers the correct amount of support to be able to implement the Care Act and the safeguarding core of that specifically. It was ensuring that all service users would be able to contribute to their care plan. But the key part of the legislation was not simply saying, well, we have to have these care plans and they have to say that John really likes his tea in the morning and that actually Joan may be allowed to have a glass of whiskey in the evening. It's making sure that they fully engage with their care plans. And full engagement can take a number of different forms. There are going to be people who, for whatever reason, aren't able to engage independently using their own voice to be able to tell you what exactly they want. But it's not simply enough for you to say, he wasn't able to fully engage. The Care Act says that I can only do it if people can fully engage. It's actually being able to use that to demonstrate what full engagement will look like. And full engagement can have a variety of different things. It can be getting a translator in. It can be talking to next of kin, though I would say next of kin, as I'm sure everybody knows, doesn't actually have a legal prescriptive definition. And so you need to make sure that the people that you're speaking to are actually people who the service user wants you to speak to and gives you permission to speak to. In other circumstances, it can be getting independent advocates in. Now, this was a core part of the Care Act and is unfortunately something that's become quite controversial because since the government cuts, getting access to an independent advocate can be difficult. But that doesn't mean that your duty stops. If you don't believe that you can have somebody engaging with their care plan, with their care and treatment package in the most appropriate way without an advocate of some kind, you must get one. You cannot simply hold up your hands and say, I tick the boxes, that's sufficient. That is not enough. There are a number of legal avenues out there, including the Court of Protection, who will help you as providers and staff get the help that you need to provide that care and support package. Because ultimately what the Care Act wants you to do is to make sure that you can get the best support available for every single service user in every single circumstance. Now, under the new person-centred approach, it has to be that local authorities have the obligation to provide that information to you. I sometimes read out this quote and there's hollow laugh ricocheting through the building, but I'm going to read it out nonetheless. Local authorities must not undertake any actions which may threaten the sustainability of the market as a whole. That is, the pool of providers able to deliver services of an appropriate quality, for example, by setting fee levels below an amount which is not sustainable for providers in the long term. Ultimately, that means local authorities have a duty to every single one of the residents within its community. It also has the duty to provide the appropriate finances sufficient to allow those service users to fully engage in whatever care and support package they need. Section 5 says that they have the obligation to do this. As a lawyer, I would say that this is one of the best bits of the CARE Act, because the CARE Act was meant to be a user-friendly piece of legislation. And as a person who has spent her entire life looking at incredibly intangible pieces of legislation, actually the CARE Act's almost there. And what it does in relation to Section 5 is it says, no, as providers, if you do not feel that you have access to the appropriate finances to do your job properly, the local authority is not holding up their end of the bargain. And they have a legal duty to the government to do so. Section 5 is your friend. There's a great piece of guidance that's next to it in relation to the CARE Act guidance document. Please do look at it. It should be used. It has been used successfully by local authorities and by providers to up fee levels in relation to individuals and in relation to general packages. I appreciate it is a very difficult financial climate, but this is a document, this is a living piece of legislation which you can use to access support. Well, on the front line, as has already been said by Jane, the CARE Act's living philosophy is the well-being principle. It's the needs and goals of the service user, and that involves a sensible risk assessment of that service user. There is a famous quote by Lord Justice Mumby which said, "What good is making someone safer if it merely makes them miserable?" Now, everybody in this room will have got into the role that they've got into to make the lives of their service users better. And a lot of the time, people translate better into safer. And it would be great if we could get all of our service users and all of our loved ones to line up in a row and wrap them in cotton wool and then maybe put them in one of those glass spheres and then put them in the corner and know that no harm can come to them again. But we wouldn't want to be that person. So why would you do that to an ultimately vulnerable, but nevertheless vibrant, unique human being? This is what the CARE Act tells you to do. It's not letting Ms. ZZ, who we've already heard of, lie on her couch in her feces for months on end, such that her joints are locked up. That's not what it's saying. It's not saying Ms. ZZ wants to be left alone, and I am using the well-being principle to say that she says, as a capacitous individual, that she has the right to do that. It's talking to her. It's exploring the options, using a multidisciplinary approach. Again, it's something that's used in the CARE Act again and again and again. Using all of the options available to you to get a treatment and support package which allows that person to trust you, to start talking to you, to get them to explore their options. Ms. ZZ wouldn't have been happy, she wouldn't have been comfortable, she would have been in pain all the time. But there may have been a number of limiting factors which stopped her from actively involving herself in the community and going to Bridge every Wednesday. That's not the ultimate goal for everybody, though it can be for some. And actually, going out into your community for some people is the lifeblood, and you facilitate that in whatever way you can. For other people, it's about taking those little steps, and as I said, giving them the options. It is a no decision about me without me principle. Again, it's through the guidance, it's through the CARE Act. It means using your multidisciplinary, using your local partners, talking to everybody you can, and exploring what the options are. But it is not reverting back to the paternalistic, I know what's best for you, I'm going to put you in the bath whether you like it or not, and I'm going to get you out of the community. That is equally not making people happy and not allowing them to involve themselves actively in the care plan. Section 42 is the way in which we get to the heart of what the Care Act says in relation to safeguarding. It replaced the no secret guidance, although terrifyingly I sometimes go on local authority or provider websites and they're still referencing no secrets. It's gone. Go to the Care Act, go to the guidance there. It's a much more workable document, as I said. But again, it's emphasising the right of an individual to live in safety, free from abuse and neglect. And again, we're going back to the well-being principle. So sharing relevant information at the earliest sign of concerns, and again, it's something that Jane mentioned, the earliest signs. That's the best way that we can get something. And as I've said, independent advocacy is available if required. In practice, what does it mean? Well, it means that you have to be available as a provider of all of the criteria of Section 42, and then ensuring that all of your staff have the relevant knowledge in relation to that. There are some fantastic examples in the guidance. One of the most impactful things, as we've already heard, is actually finding out what does this mean for a service user in practice. And sometimes it can be a conversation with that service user about how to keep themselves safe, about how to help them. Sometimes it's calling the police and closing the shutters. There are a range. But it is not simply enough to say, well, I passed it on to the police, it's not my problem anymore. One of the most brilliant examples in the Care Act is of a young learning disabled gentleman who had access to his own finances, but was being financially abused by strangers. And it was about having conversations with him about his money, still allowing him access to his money when he wanted it, but before he used it, sitting down with a key worker and exploring why he was going to use that money, in what ways, what were the implications of that going to be. That's something that every single parent would probably try to have a conversation with their teenagers about before they go out. So why wouldn't we do that to the most vulnerable people in society, under whose care we have responsibility for? It's again, trying to find out the least restrictive option to make sure that person can live their life properly. Now, on a basic level, as a lawyer, I would say that this comes down to what do your policies and procedures say, because without those policies and procedures, everything else is irrelevant. You can't do training on blue sky thinking. You have to do it on what your policies and procedures say. These should be based on the statutory guidance itself. And again, that statutory guidance shows a range. There's a fantastic document which is guidance for providers on developing internal audit, adult safeguarding policies and procedures. And it shows exactly what Jane did, of different sections, different potential queries, different potential concerns, and what your responses should be at every single level. Because again, it's not necessarily just having a cup of tea and it's not necessarily calling the police. There are different ranges in between, and you need to know what that range is. And you need to know that your staff are confident in knowing what that is. Now, best laid plans. The Care Act was supposed to be the document to end all documents. It was supposed to ensure that we unified standards across legislation. As I said, I've seen a number of documents that still reference the no secrets guidance. It's possible that the message hasn't entirely always got through. So it's vital that when you're drawing up your policies and procedures, when you're considering how to implement them in practice, you're not just considering the Care Act. You're not just considering the statutory guidance. You're considering what that looks like for you at a local level. What does that look like in Lewisham? What does it look like in Bromley? What are you going to be tested against by your safeguarding alert team when they come in, when you have had a concern? You need to be able to test these documents. Go to your local safeguarding adult board. Actually talk to them about your policy. What do you guys think of my policy? Try to engender relationships with people so that once again, you are working as a multidisciplinary team with your local health and social care leaders. But your duty doesn't just end with the Care Act itself. If Section 42 isn't triggered by whatever your circumstance is, it is still important that you carry out the proportionate inquiries in relation to that situation. And again, I know it's a lawyery thing to say, but please document it. It is absolutely useless to do the best safeguarding inquiry you have ever done in your life and do it on the back of a piece of paper and then lose that piece of paper. You need to make sure that you have folders for these things, that you're talking to the right people. But when you're talking to the right people, if you're having that conversation by telephone, as many of us are when we're rushing from base to base, making notes, sending them an email afterwards. Great to talk to you about X. This is my understanding of the conversation. This is how we're going forward. Do you need to CC other people into it? Because you know that X is also in contact with this organisation, or that local safeguarding group, or that care home. Well, they all need to be a part of the conversation. This is not a siloed operation, but making sure that every single person has a written understanding of how you're going forward and why you made the decisions that you made. Because from a self-protection point of view, that is the only difference between you being in court and having to justify it, or having to justify it to the serious case review with your knowledge of something that happened 18 months ago and the hundreds of clients you've had since then, and you actually being able to look at a piece of paper and say, no, I did this on the 21st of July because I had that conversation with that person. It is absolutely vital that you do that. I'm not going to go into the details of the Mental Capacity Act and DOLS, for which I'm incredibly grateful because I have to do this on a regular basis, because I hear you've got an excellent breakout session coming up. What you're going to learn from that, as I'm sure you already know, is that every single member of staff at every single level has to have at least a basic awareness of safeguarding. And I do mean every single member of staff at every level. And again, use real life examples. Make your training real. There is absolutely no point in a care home talking to your staff about what safeguarding looks like in a police cell. It doesn't translate to their daily life. You need to make sure, and again go back to the Care Act guidance because it is really useful, that what you're doing is a real world impact, so that when your staff member comes across something, they know what to do because they have had that teaching. But again, it's not simply enough to go back to your policy and procedure. If anybody is aware of any safeguarding concern, and again, this is something that's come out so strongly from what we're hearing in relation to Oxfam, if there are any concerns, if you have passed it on, but you don't think anything is being done about it, that is not the end of your duty. I often say this and people say, oh, but you see, I'm not a nurse, I'm not a doctor, I'm not a dentist, I'm not regulated. I'm merely a volunteer in a local homeless shelter. The Disclosure and Barring Service does not care about that. And this is the point that I normally bring this up, because every single person who has got an enhanced criminal records check, which is hopefully the vast majority of people in this room, if you're working with children or vulnerable adults, can also be investigated by the Disclosure and Barring Service. And unlike being a nurse, and the worst sanction that can possibly be applied to you is a strike-off, which is awful. It's the end of your nursing career. You will never be able to nurse again, but you will be able to probably get other jobs in the sector. If you are barred by the Disclosure and Barring Service, it is not simply you cannot work in care again. It is you may not be able to ride your child's bus to school. You may not be able to work at the church. You may not be able to be part of the creche in your local synagogue. It is so wide-ranging, and so few people understand the implications of the fact that they have got a DBS. Every single person that works with children or vulnerable adults has a direct responsibility to raise concerns, act on concerns, and follow up their concerns. And if they don't, there are legal implications for not doing so. Sorry, often I'm here just to scare people. But this is something that scares everybody anyway, so it's fine. This is the Care Quality Commission. Many of you aren't going to be regulated by the CQC, but many of you will be. And actually, what the CQC ties in relation to their legislation is applicable to everybody because it takes some really great NHS and local authority guidance in any event. But ultimately, CQC, if you are regulated, you have a duty to report concerns. You have a duty to guarantee that safeguarding is implemented in a real-world level, and you will be rated against it. You must investigate any concern unless there are compelling reasons why not to. As with the Charity Commission, as with the Care Act, it is not simply appropriate to report and walk away. Not sufficient for the Care Quality Commission. The CQC must inspect the safeguarding arrangements of services in each comprehensive inspection. In fact, even in the non-comprehensive inspections, where they are rating 1 or 2 domains, safeguarding is still going to be a part of that because, as we've heard from Jane, it's all encompasses. There are 3 main questions that are asked. Do staff know what abuse is and how to spot it, or how to spot when people may be at risk of it? Do staff know how to act when they spot abuse or the risk of abuse? And do staff learn from safeguarding incidents and risks? And may I just reiterate, I do mean all staff. When CQC come in to do an inspection, they are not simply going to talk to the person that is doing the drug round with the tabard on. They are going to be talking to the administrators. They are going to be talking to the gardener. They are going to be talking to the daily or job man that comes in. Because every single one of those people has the possibility of having unsupervised access with a child or vulnerable adult who is under their care. Every single one of those people has to understand the implications of your policies and procedures, how you're implementing them, who they could contact, who they can turn to. It is also important to understand that you can test what you already have against what CQC will be looking for. Now, CQC sometimes can be accused of working in some weird and wonderful ways, and as a person who reads CQC reports and defends providers on a regular basis, I would absolutely wholeheartedly agree with that. But they have to be a transparent, quasi-governmental organisation. They have to tell you what they're going to be looking at. And the list here is things that they will be looking at. It is important to notice that the Care Act is the minimum requirements. CQC themselves have their key lines of inquiries, otherwise known as CLOEs. New CLOEs came in November 2017. Again, a number of providers and staff haven't been told about it yet because it did come in rather quickly. Please go back to your organisations, if you're regulated by CQC, and check that you are aware of the new key lines of inquiry and what they look like. They're actually more user-friendly in that they are more global rather than prescriptive to a particular sector. They are mandatory key lines of inquiry. So please, again, do go back to them. Well, the new one for SAFE looks like this, and this is just a small amount of it. Again, SAFE is not the only domain against which they rate safeguarding, but it is the most obvious for the principles of today. And section 6, our lessons learned and improvements made when things go wrong, leads on to another section of what CQC rate against, which often people seem to have a weird disconnect from this and safeguarding. And that is in relation to complaints handling. The reason that complaints handling is so important to safeguarding is that this is often where the issues get raised at a lower level. It is mum coming in to a home and being concerned that son has been left with the same pad since she was sure that she last saw him. It's going in to a care home and thinking that the pyjamas definitely look like they have dried fecal matter on them which hasn't been cleared up for a short period of time. These are the things that form discrete complaints, but they can be the things that demonstrate systemic issues in your organisation. If you're not dealing with your complaints handling and linking that to your safeguarding, then you are leaving every single person in your care vulnerable, and you're also leaving yourselves vulnerable to criticism from CQC. Well, they have introduced new sections in relation to complaints handling themselves, and it comes under their section R4. Again, it's ensuring that people know how to make a complaint, that it's easy for people to use that complaints system. It's all very well to say, oh, well, I know that the complaints document is located on the front desk, but if it's 5 pages long and incredibly dense and no reasonable person is going to understand it, that is not a usable document. And importantly, it's not an open and transparent document that people can feel confident in using. So you need to translate that document into something that's user-friendly and encourages complaints and encourages comments, because that makes your service better. That makes you more protected and less vulnerable. And also, again, at the bottom, we have the words continuous improvement. What CQC wants to see is not just that you have a document that you've written, again, as with the Care Act, as with trustees' obligations to the Charity Commission. It's about ensuring that that is a workable document, which is being reviewed. If you have a couple of complaints, what have you done about them? Have you tried to consider whether there is a pattern of complaint management, whether there are concerns in relation to particularly certain times of day when safeguarding issues appear to come up, whether there are particular staff members who seem to be the index point between different low-level concerns? You need to be monitoring and you need to be reviewing. Well, why is complaints handling itself important? And I love this statistic because CQC has revealed statistics on this and have said that they receive 280 items of feedback a month and that 15% of those are positive. I really like that. I like the fact that 15% of them are people taking time out to provide positive feedback. However, 85% of them are not. Now, 24 of those prompt a safeguarding referral. 14 prompt an inspection. 43%, that's 103 concerns, may be used to inform the next inspection. This is really important because a number of times providers come to me and they say, well, the inspector asked me about something that was resolved 11 months ago. How did they know about it? Well, they know about it because the same person who came to you to complain and didn't think that they got a sufficient response has also gone to CQC, and CQC has logged it, and CQC has considered it. And what your response has to be is, well, we understand that Ms. X had a complaint. We understand that she had a concern about her loved one. Here's our lovely set of documentation about what we did. Here's how we monitored all of the good lessons that we learned from it. And here is what we are doing going forward to ensure that that particular concern or complaint isn't raised again, or if it is, we've learned lessons about how to handle it. CQC love documentation. It makes their lives easier, and you having that documentation wildly makes your life a lot easier. Well, the implications of not doing so are, of course, incredibly serious. If your expectations are not in line with your local safeguarding expectations, then you are simply carrying out a tick box exercise which doesn't have any real world implications. For the Lewisham Safeguarding Children's Board, for example, there is an expectation that if you report to a manager, the manager reports within 24 hours. That's non-negotiable. It's written down. Do you know whether the managers in your organisations know that that's an expectation? Do your staff members know that it is actually an obligation for your manager to have reported it in 24 hours? If they haven't done so, why haven't they done so? Again, the reasons that allegations should be referred are wide-ranging. Behaving in a way that has harmed or may have harmed, possibly committed a criminal offence, behave towards a child that indicates they could pose a risk. It is not up to the person on the front line to make the ultimate judgment call as to whether or not this is going to be a criminal offence. That's not for you. That's not for me. That's for the Crown Prosecution Service. We're talking weeks, months down the line. The obligation for every single person in this room and every single person that they work with is to ensure that they have the knowledge and the confidence where they have concerns, to take it upon themselves to report those concerns and to do whatever they can to ensure that those are taken forward. And if you don't, there are implications. Now, I'm not going to go through these in any great detail, but it's really useful to look through them. I've given summaries of some of the offences themselves and some of the implications of them. And again, it just demonstrates the really wide-ranging nature of what safeguarding looks like in a criminal context for us now, as it well should, because there were a number of things that used to fall through the gaps. The arguably newest of these is continuous controlling or coercive behaviour. Again, something that we've seen in the media a lot, technically came into legislation in 2015. We're starting to see the first criminal offences, criminal convictions coming through now. It's important that your staff members understand what this looks like and how to report it. Likewise with health and safety prosecutions. Now again, I'm not going to go through this, but you have some significant examples. These are criminal and civil offences which can lead to fines. They can lead to prison sentences. They can certainly lead to DBS referrals and marks in relation to that. These aren't examples that I want to use to scare providers and to scare staff, but they are essential in understanding where other providers have gone wrong and taking advantage of the knowledge that you've sadly got from what they have done to ensure that you never make those mistakes, and that you as providers, as staff members, as volunteers, as trustees are doing everything that you can to ensure that you have the best practice grounding in your policies and procedures, and that you know that you are confident that those are being implemented in practice. Thank you very much.